Chairman, look, just in response to the honourable member's comments, perhaps I could just make 3 or 4 quick remarks. The first is that the need to expedite these matters before the courts and to ensure that that process doesn't divorce itself from quality representation and quality arguments is critical to a range of things the government is undertaking across the justice area at present. I can tell him that if he holds his breath for long enough, help is on the way in the civil jurisdiction. We're dealing with the criminal area. The family area is next on my radar. We've been doing some things around simplification of the court process itself. Of course, it was his government that had the foresight to legislate for the removal of depositions, and this government that instigated it. We are making progress. Just to the matters contained in Part 3 of the Legal Services Bill, and in particular around community law centres, I share the member's view that it is the role of community law centres to provide legal services to clients who cannot afford to seek that advice by way of payment directly from a law firm. Of course, the member might not be the case in the member's part of the world, but many of these community law centres actually employ full-time lawyers. So the ability to simply hive people off to another firm is not always the case with some of these bigger community law centres around the country. One of the things that we're working hard towards is consistency of advice across those community law centres, sound governance arrangements across those community law centres, and relevance to a particular community to make sure that the skill set is correct. Now, those 3 categories of compliance have had diverse contributors to them, if I can put it that way, over the course of the last while, but I can assure members of the committee that this government and I are committed to the continuation of community law centres and the quality service that they provide. So a couple of quick responses to Charles Chauvel, some of the comments that he raised. Firstly, the statutory obligation to consult. Just wanted to briefly advise the member that the consultation provisions in the 2000 Act frankly were used to stall and slow down legal aid reform during previous times. It made the development of the Public Defender's Service, for example, much slower and far more expensive than it should have been. My experience has been that having a codification of statutory consultation actually invites that type of process to occur where differing benefits accrue. And so on that basis, I have no doubt that consultation will occur where appropriate. With respect to legal research and education, as I'm sure the Secretary may undertake or fund law-related research and education rather than must. Law-related research and education is a traditional yet very small part of this particular vote and of the legal aid scheme.
Members, the question is that Part 3 stand part. Those of that opinion will say aye. Contrary will say no. The ayes have it. We now move to the vote on... Ayes have it. I'll ask the clerk for a party vote.
New Zealand National.
58 votes in favour.
New Zealand Labour.
41 votes in favour.
Green Party.
9 votes opposed.
ACT New Zealand.
5 votes in favour.
Maru Party.
4 votes in favour.
Progressive.
1 vote in favour.
United Future.
1 vote in favour.
On Chris Carter. Hone Harawira. Any other votes?
Members, the ayes are 110, the noes are 9. Part 3 will stand part. We now come to debate on Part 4. This is clauses 100